What France can learn from India? White can learn positive secularism from India. Till 2009, UK did not have a Supreme Court. For media, there is no pre-censorship. Supreme Court did not allow DNA tests. State does not have exclusive jurisdiction on water. In historical, just read one thing. Government of India Act 1935. इसको प्रीलिम्स के लिए छोड़ दो. बस फीचर्स में भी कुछ नहीं है. Amendments we leave because the amendments which they ask, let's say that, so if the amendments they will ask anything that is related to 84th. This that way. So that will come in federal aspect. Federal is also part of this. This way. Other amendments are unpredictable. They have been asked only when they were in news. So whatever the amendments can be in news, you should be prepared. So we cannot prepare those amendments. Anyhow, you have to read for prelims. So some amendments you will read for prelims, First Amendment and others. On that basis, you can write. So that way you can say significant provisions not needed. Basic structure, so you can read, although questions are not that way asked, but basic structure, what we have to read in this. When you read fundamental right, you read basic structure. Yes. So it's not that we have to memorize those basic structure, the part of fundamental rights. This way. So that is how it is. Comparison is something you should read properly. This. Right. जो सबसे बड़ा हीरो है वो ये है. Because most of the time or every year almost they have asked question. And since they have asked already that number of questions, the next question will not be easy question. इसलिए कि जो easy part है comparison का वो they have asked. This that way. तो sectoral तो content होना चाहिए लिखने के लिए. That is how it is. So what you can, that is how it will reduce your efforts. Let's say this. Now, as far as next day is concerned, functional responsibility of union and states. So let's say that it is executive part. In executive, largely they have asked, let's say, question related to president. This governor से तो आया नहीं question, let's say, in that way. Although they have asked, but not the way the governor remains in news. This, but still you can, let's say that, take governor because infamous person तो कभी भी आ सकते हैं. This, then question related to federal, so that is again it is most important. Among them it is most important. This, the federal is something we should focus. Devolution of power, finance to local bodies, etc. तो local bodies भी part यहीं पे होगा शायद. I guess local bodies is also there. No. And local bodies challenges. It means 73rd, 74th also covered. ये कहीं और है इसमें. Yes. It is also here. Right. 73rd, 74th. They are also important. 73rd, 74th. The separation of power, पढ़ना क्या है? You don't have to read separation of power. Right. This, it is presumed that there is separation of power. Right. This, we don't have to read as such. When you read polity, you are, let's say, indirectly reading separation of power. This you can say. Then various organs, etc. But they have asked question. So basically, what you should read in that 1 week, in this week, is if you go down, or let's say from this upward, the 73rd, 74th Amendment Act, because this is most, let's say, one of the most important topics. We have इसमें fundamental rights तो mentioned ही नहीं है. Significant provisions syllabus वाला topic mention है नहीं. तो 1, 2, 3, 4. Basically, you have 4 important topics to read this week, which you should give priority. The first is fundamental rights, which is not clearly mentioned. The fundamental rights, especially 19 and 21, that one. And second is called comparison. So first is fundamental right. This second is comparison. This third is federal structure, and fourth is this. So that way it will be doable. If you see the length of syllabus, so it will be challenging. But we prioritize as per questions, so then it will not be that challenging. That way means you should read other things by giving less priority, read them by giving highest priority. Now, we have given you notes, and we'll give you some supplement handouts. The supplement handouts, because some of the things are not in those notes. So we have made notes on them. They are a bit lengthy because short notes we have not prepared on them. So you can read by this time. Like we'll upload on portal. You can get access from portal. Yes. Today we'll upload comparative constitution of France and US and UK. Then constitutional morality, and then this called constitutional morality, and one more topic, secularism. This, because these topics are not in these notes. Online people, you will get access to notes. Means ke courier time it will take 2 days almost. By that time you can read by your own notes. You may have your own notes. That we can consider. So this is what for this week. Right. So let's meet after 1 week. So let's take some memory test, isn't it? ताकि पता चले कि how much you are prepared. नहीं, अभी नहीं. So 2016, already you may have read these things, isn't it? This question is also uploaded on portal. Many of that, let's see, you can download this question analysis. So just till one defining line for this question. Did Government of India Act 1935 lay down a federal constitution? This? Yes, okay, good, qualified. This. So, are they defendable, the objectives?
You will write largely yes, and then few weaknesses.
What are the adjectives?
Sovereign, secular, democratic, republic,
Sovereign, 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 socialist, secular, democratic republic.
Right. तो रिपब्लिक तो लिखना नहीं है.
Adjectives.
Right. You don't have to write on republic. You have to write the preceding. So you have to write socialist, secular,
Democratic. Democratic.
sovereign, socialist, secular, democratic. 4. So how you will write it? 4. क्या अलग अलग लिखोगे आप?
We'll make columns and then we'll write their defendable and in one column fill problems.
Yes, तो basically you should write by इसलिए कि आप holistic नहीं लिखना है. You have to write each one and just write one liner of definition. The one liner of definition of that you write. Then after that you have to write defendable and that column write less defendable. So less is subjective. This once you write it तो आपको लेस वाले में कोई एक नेगेटिव फैक्ट होना चाहिए. पॉजिटिव आप तो हो गए ही. लेट्स से दैट वे यू कैन राइट. टुवर्ड्स एंड यू कैन गिव योर वे फॉरवर्ड टाइप थिंग. That way, this transitional constitution, transitional society, by and large, you can say that it has worked. We have implemented this, and further, let's say that down the line, right? Anyhow, so basic tenet on which two political systems are based. क्या है basic tenets?
Stability versus responsibility.
Yes.
separation,
Yes. और
SOP अपने यहाँ पे जो है वो डिफाइन नहीं है, उनके यहाँ पे क्लियरली जो है वो मोटिवेट वाला SOP.
Double citizenship. Strict federalism.
till the 4 defining tenets, prominent 4 defining tenets, right? The prominent 4 defining tenets, one prominent is presidential versus parliamentary. Second is, yes, judicial supremacy versus constitutional supremacy. Next, उसी में separation आ गया. Next,
Strict federalism.
yes, classic federalism versus quasi-federalism. And next,
Oldest constitution versus lengthiest constitution. Double citizenship.
yes, अभी ये भी हो सकता है. तो absolute right versus qualified rights, that can be also written. Rigid versus flexible constitution. Rigid versus flexible constitution. And rigid separation of power versus flexible separation of power. The 4th, 5th, etc. That is how it can be. That way you can compare. Let's say France. What France can learn from India? Why it can learn positive secularism from India? What is our secularism? No, you have to have keywords. You are giving explanation. I am asking keywords.
for minorities.
Oh, you are explaining. We are asking keywords. Chalo, any online person, can you tell keywords of difference between Indian secularism, Western secularism? No explanation, tell keywords.
No interference, constructive interference. Harmonious functioning of state.
Yes?
Harmonious functioning of state and
So, arm length approach.
Anyhow, we say it as principal distance model. Indian secularism is principal distance model. Principled distance model. Right? Bracket Rajiv Bhargava. Principled distance model. The Sarva Dharm Sadbhav. Sarva Dharm Sadbhav. Inclusive secularism. Plural secularism. No doubt, positive secularism. They have negative secularism. Wall of separation. Wall of separation. In bracket, Thomas Jefferson. This exclusive secularism, negative secularism. Thomas Jefferson, wall of separation. This. So their state has no interference in religious affairs. In India, state has, let's say that role to interfere so that it can create a level playing field. A level playing field, welfare, justice, it can eliminate discriminations, these things, let's say. That is what we see this. Right. So this way it can be considered. Anyhow, let's take next. Judicial system and UK judicial system. Let's. So how this convergence and divergence. What is diverging? ये तो meaning पता है that.
Initially, their Supreme Court was part of Parliament.
नहीं तो उसका term होगा ना.
House of Indian Supreme Court is provided by Constitution.
Tell the term. Explanation नहीं.
Constitutional statutory. Judicial independence.
Sir, we have adopted common law from the country, so writs and all are basically from UK only.
No, वो तो convergence we are talking. We are talking divergence.
The collegium system itself is a divergence.
Collegium system is extra constitutional development. Can it be a matter of comparison at first place? Our judicial system resembles US based on separation of powers with judicial independence. UK lacks separation of powers. You can say. The UK judicial system is based on common law practice, where there is a parliamentary sovereignty, parliamentary supremacy. Yes. So there is a lack of separation of power. We have separation of power. Their judicial independence. The judicial independence, rather it is parliamentary sovereignty, parliamentary supremacy. the subordination of judiciary to parliamentary system. We have constitutional supremacy. The constitutional supremacy means that no organ is subordinate. Rather, it is independent. That can be considered. Then it is, let's say that there is no any fundamental law. It lacks judicial review power. We have judicial review power because constitution is a fundamental law. So these things can be considered convergence. When we are writing.
UK judiciary system has judicial review of executive.
No, it has, but वो तो हो गए. But then it is not the way you have in our country.
So we need to explain that, or we can just write judicial review and go ahead.
No, we will not consider its power of judicial review as a prominent power. Right. Because let's say that their judiciary is, there is no fundamental law, no constitution. How the power of judicial review comes? It is the guardian of the constitution. Judiciary is the guardian of the constitution. But their judiciary is not a guardian of the constitution. Rather it is the parliament which is the guardian of the constitution. That way we will not talk this. Getting? When we say divergence, in divergence we will compare कि our judiciary has judicial review power resembling to separation of our independence. There it lacks that independent judicial review power. That we will say.
So they do have limited judicial review.
बिल्कुल.
Why shouldn't we mention the basic structure doctrine as well? Because that
Basic structure doctrine is again evolved.
But the question mentions practices. So it
Direct.
is a part of practice.
It is evolved, let's say that. Then you can mention it, but not at first place. We should mention, let's say, but because first let's mention ki in theory what you have, the difference. Then we can compare the practices. Right. When you compare the practices, then you can bring collegium system or basic structure doctrine, that aspect. Then procedure established by law, you have both procedure established by law and due process of law. That way.
Sir, can we say our judiciary is constitutional and the judiciary is statutory? That's because there is no constitution.
But वो कोई point नहीं है. Right, वो कोई point नहीं है मतलब, because their constitution.
To show divergence.
Right, you can add a point, but then it is not that relevant. No, देखो ये सारे सब्जेक्टिव चीजें हैं. राइट, उनके यहाँ भी जुडिशियल ओवररीच होगा, बट हम नहीं जानते. यस.
Judicial independence for UK versus what for India?
Judicial?
Independence versus
No, they don't have judicial independence.
mix up हो गया था.
No, this lack of judicial independence or weak judicial independence versus strong judicial independence. ऐसे लिख सकते हैं.
And that is because our constitution provides judiciary, that's why.
Yes, our constitution guarantee that independence to judiciary.
In one source I read judicial independence. UK has judicial independence. That's because they have independent judicial commission. And India has collegium system. That's why India lacks independent judiciary.
ये सब अब again कि we will get stuck. Right. Try to understand that कि our independence resembles to US. What V.R. Krishna Iyer says, Indian judiciary is the second most powerful judiciary. Right. Why it is second most powerful? Because of independence. I do not know that source, what they are writing like this. Right. Let's take that कि UK judiciary can strike a law, but there is no constitution. So when there is no constitution, it cannot strike a certain provision of constitution. Our judiciary can strike even an amendment of the constitution. Then it has evolved basic structure, let's say this. The judicial independence in their country is not because they have that system. The judicial independence is because the rule of law has evolved in their country. constitutional morality is evolved in their country. Constitutional morality is not a natural sentiment in our country. This इसलिए तो पिछले साल का जो क्वेश्चन है, हाउ कॉन्स्टिट्यूशनल मोरालिटी गारंटीज इंडिपेंडेंस ऑफ जुडिशरी, तो उनके यहाँ कॉन्स्टिट्यूशनल मोरालिटी है, तो वो नहीं भी रहेगा तो वो इंडिपेंडेंट ही रहेगी जुडिशरी. This that becomes subjective. That I will say. तो the point A right कि collegium system versus this and that, ठीक है, we can write it. I am not telling means objecting it, but then कि let's say that कि till 2009, because they changed by law 2005, it became operational in 2009. Till 2009, UK did not have a Supreme Court. This, its Supreme Court was House of Lords. And then it was presided by one such British cabinet minister, who is a law minister. This. So that was lesser. But they have writ system. See, try to understand. This is a land where rule of law came. So, जाहिर सी बात है, whatever the system they will have, it will be better. This. But that subjectivity we do not have to go. This. Anyhow, the next point we are saying is, this is divergence, we can say. Convergence, what can be convergence, by the way?
Integrated judicial system.
Yes, the integrated judicial system.
Supreme Court final court of appeal.
Supreme Court, Final Court.
मतलब वही हो गया था सब point.
ठीक है, सुप्रीम कोर्ट फाइनल, ये कोई पॉइंट होता है? प्रोसीजर एस्टैब्लिश्ड बाय लॉ, रूल ऑफ लॉ. यस, ये सब पॉइंट पहले लिखना चाहिए, राइट? रूल ऑफ लॉ, प्रोसीजर एस्टैब्लिश्ड बाय लॉ. दिस, दैट कैन बी writs, you can say writs, right? But वो जुडिशरी से रिलेटेड नहीं है ना, बस right? जुडिशरी से नहीं है, that's this, that can be considered. So those things can be written like this. Practices, so basically you can talk कि let's say कि we are also means कि there is greater convergence in terms of giving independence to judiciary, transparency in appointment process. Let's say कि they have also judicial appointment commission. We have also tried to adopt judicial appointment commission. This, those things can be.
Sir, like if in divergence we are writing judicial review as diverging point, so can we write judicial review of executive action as converging point in convergence?
Yes, it can be written. It can be written. This judiciary convergence means review of procedure established by law. So when there is procedure established by law, so then the judiciary can review the acts of executive. This, that can be, right? Anyhow, let's take next. So इक्वालिटी इतना ज़्यादा डिबेट नहीं होना चाहिए, नहीं तो फिर विल नॉट कवर. जस्ट वी वांटेड टू हिट सम ऑफ द थिंग्स, लेट्स से हाउ यू शुड थिंक एंड सम की टर्म्स एटसेट्रा. रेस्ट यू रिवाइज, यू विल नो दिस. देन एनालाइज द, लेट्स दिस notion of equality in US and India. Notion of equality in US and India. So what is notion of equality in US? Use key terms. आज से ये सीख लेना, ठीक है? Try to learn to speak in keywords, not in subjective words. Yes, that is the right way to talk. The notion of equality in US is positive or negative? US has negative. whether US has negative equality or positive equality. Positive equality. Because equality, equal protection of law. The equal protection of law is positive equality. You will have to write this notion. Notion of equality in US is positive. This, as it has equal protection of law, that has a room for affirmative actions. Equals are protected equally, unequals are protected unequally. Right? This way. Then India has both positive and negative notion of equality. So that way. The positive is equal protection of law, negative is equality before law. Right? Equality before law is rule of law. It imposes restriction. Right? This imposes restriction, this unarbitrariness of the state. But equal protection of law empowers the state to take this. In pains ki our, let's say ki notion of equality is broader than US notion of equality. And then you can tell ki how our notion of equality is broader, that has resulted into positive interpretation and bringing intelligible differential, let's say that. Means ki Article 14 gives opportunity, means ki power to the government, scope to the government for what? Positive discrimination. This you can say that. Reasonable classification. This, it gives scope for reasonable classification, like EWS is so far reasonable classification. So far वाला मत लिखना. Anyhow, so have you read, ऐसे पढ़ा है? Have you read fundamental rights like this? नहीं, मैं ये नहीं कह रहा हूँ कि उसका don't take other way. I'm asking कि have you read polity that way? क्यों नहीं पढ़ा है? है ये सब कोई बात नहीं है. लक्ष्मीकांत में नहीं है तो लक्ष्मी में तो है ना. With not, I don't mean gods and goddesses. Right. नहीं तो अभी बुलडोजर चल जाएगा. Right. Anyhow, that is equality. Let's come this. So, the examine procedure through which President of India and France are elected. Yes. It is a specific question, you know that. This. So, ours is, let's say that कि अब our तो पता ही है आपको क्या procedure होता है. France procedure is direct election. This. Plus, there is a criteria of 50% plus 1. And if let's say that in first round it does not, any candidate gets, there can be even second round of election. This, that way. Further procedural details you read in the notes that we have given. Next. ये तो simple question है. Compare and this, then discuss Indian secular. This is a secular, compare with secular principle of US. तो वो क्या था? France. ये फ्रांस का था. दिस तो फ्रांस में एक दो पॉइंट ऑड ऐड हो जाएगा व्हेन यू आर राइटिंग. तो फ्रांस इज बेसिकली, लेट्स से दैट कि दे हैव public restriction, let's say that. This US does not have that. So France is one step ahead of US in negative secularism. Even there is public restriction of manifestation of any religious symbol and practices. France has this. And it is less multicultural, you know that. US is more multicultural, but it is less multicultural. This, it has not only negative, it has a narrow secularism also. This narrow secularism. Because secularism does not mean it should curtail freedom of people. But its secularism has started also restricting freedom of people. This. So that way you can practice. So it is similar to that. Discuss secularism. Then 2025 they ask judicial India and US. India and US pardoning power, I guess. India and US judicial pardoning powers. Differences. No. So differences are that 2025 का question जो था, differences are this के Indian president also enjoy federal pardoning powers. Federal means कि cases are also related to states which are death sentence or let's say even military court martial. This the US president does not have federal powers. So those let's say cases which are related to states, since they have parallel states, the president does not have jurisdiction. This is one. Second is that ki their president power is absolute power, stand-alone power. But in India, it is not stand-alone power. President has to exercise as per the advice of Council of Ministers. This, so that we can consider. Then next is that ki there the president power is not subject to judicial review. Our president power, pardoning power is subject to judicial review. Next is that the president has preemptive power. That was the key aspect of the, let's say that, preemptive power. Preemptive power is that at trial stage itself, president can give pardoning. This, like Richard Nixon was given pardoning at trial stage. So, a president gave pardoning to another president, ex-president. This, so this is how let's say that ki preemptive power. Our president has post facto power, not preemptive power. So these are some differences, let's say that. What you learn from this is that ki you should use this. So not able to understand what you are trying to say. I am at work, I will do it now. This. तो यू शुड लर्न की वर्ड्स. आप की वर्ड्स में सोचना शुरू करो, नहीं तो आंसर में आप लिखोगे दिस लिटरेचर. लिटरेचर जो ऐसे में भी लिटरेचर ही आ रहा है, राइट, जीएस टाइप. Anyhow, so both are two different things that you should know that. Let's take next. That will skip, it has no relevance, right? 66A. Now, आप दो लाइन में डिफाइन कर दो फ्रीडम ऑफ स्पीच और एक्सप्रेशन क्या होता है. Yes, any other? freedom of speech and expression means a citizen is allowed to speak his mind. Right? Speak his mind, which is essential for fullest attainment of potential of citizen, individuals. That is how. Further, you will elaborate on this. This freedom of speech and expression is an inalienable part of, let's say, human expression, human existence. This, which is a modern liberal development. This, and citizens are entitled for freedom of speech and expression with reasonable restrictions. Means India has qualified freedom of speech and expression under Article 19(1)(a), and there are restrictions under Article 19 Clause 2. This, that way. And then you can give any example ki any citizen, let's say, ki expressing through protest, expressing by writing an article, right, or a media which is, let's say, that ki expressing on behalf of people. ऐसे थोड़ा सा elaborate करोगे depending this. That is how freedom of speech and expression. Does it cover hate speech? Yes. Right. So hate speech is one of the reasonable. Right. Now, then you will say, since there is reasonable restriction, so freedom of speech and expression does not mean that one is free to speak anything in any manner. This. And then you can give the reference of Voltaire. I can die by defending your freedom, but I cannot defend what you speak. This, that line will come this way. Then hate speech you have to define. What is hate speech? Can anyone define what is hate speech?
Defamation and incitement to an offense or some public prohibition. Disturbs the harmony of the society.
Hate speech is the words which are intended to create disharmony in the society or spread the manner.
नहीं, ठीक है, केस लॉ बता दो जिसमें सुप्रीम कोर्ट ने डिफाइन किया था.
लॉ कमीशन है तो बिलाल
Law Commission 267.
प्रवासी भलाई केस 2014. प्रवासी भलाई केस 2014. This. Now, hate speech is defined as something it is directed against any particular group, right, with intention to ostracize, boycott, delegitimize, which can be a groundwork for higher violence against that group, including ethnic cleansing. That was Pravasi Bhalai definition. This. Anyhow, ठीक है, हम किसी भी तरीके से डिफाइन कर सकते हैं, कोई मतलब ये नहीं है कि वी हैव टू नो. बट देन की क्वेश्चन आया है, वो भी कब आया है? 14 में. और कब आया है? जजमेंट आया होगा ना, प्रवासी भलाई केस 2014. ठीक है, तो उस समय लोग जानते होंगे जिन्होंने they may be aware. Anyhow, so that way we can consider. Then now, why do films in India stand on a slightly different plane from other form of expressions? Yes, one is more impact on society. Second, वो सेम ही काम, सेम ही बात होगी ना, more impact on.
Visual medium has more impact than
Same point. Tell another point. देखो, film we have to portray a particular character. So when we have to portray and depict a particular character, to depict that exact aspect of the character, the actor who is playing that, artist who is playing that character, he should be allowed to have that freedom. Yes, because that artist does not intend to really do in actual life. But for depiction of that in picture, it is essential that he should be allowed to even abuse, allowed to have hate speech. Right. But that will not be considered something as hate speech in actual practice. Right. कि that actor नहीं कल को उसके घर के सामने पहुंच जाओ. Right. Anyhow, that is how it is important. The two things are important. One is it has wider impact, and second is that you have to depict that particular character. This now. So that way. Then what are the case laws? Do we have any case laws? This Rang Rajan case. Right. The Rang Rajan case, let's say. So Supreme Court says that a movie can stir up emotions of the people more than any other things. This. Hence, films should be given different treatment in terms of restrictions than any other medium of freedom of speech and expression. This. So, in Raj Gopal case, you should know that. Raj Gopal case, मैं भी भूल रहा हूँ. Jagjeevan Ram case, Raj Gopal case. In Article 19, we have case, let's say, Indian Express case, Bennett Goldman case. Rangarajan case है.
वही S. Rangarajan versus P. Jagjeevan Ram, 1989.
They have told कि pre-censorship is, it is pre-censorship. Brij Bhushan case. Yes, got it. Right. Yes, in Brij Bhushan case, Supreme Court did not allow pre-censorship. In Brij Bhushan case, year क्या है? नहीं, year. 19? Brij Bhushan case, 1950. Yes, the Brij Bhushan case, 1950, Supreme Court told that there cannot be pre-censorship to media. Right? Now, in Raj Gopal case, you are saying, Jagjeevan Ram case, Rangarajan case, Supreme Court told that there can be pre-censorship to films. Yes. So films के लिए there is pre-censorship, but for media there is no pre-censorship. The Brij Bhushan case was related to media pre-censorship. That is not permissible because media operates on a different note, film operates on a different note. There can be pre-censorship, means that before film is screened, you can have censorship on that. This just to show you some parallel and differences. When you read it, you know them. This. Anyhow, but इसमें उसकी ज़रूरत नहीं थी. Just we have to relate कि what are the why different plane discuss. Let's say this weakness we can talk like this. Let's come to this. Now, does the right to clean environment entail legal regulation on burning crackers? वो तो cracker वाला judgment है. This during Diwali. अब तो ये चेंज कर दिया है उन्होंने, अब खुद ही चेंज कर दिया, राइट. So that time Supreme Court completely banned this firecrackers and it allowed green crackers only. This that way. But now they have allowed, right, sounding crackers they have allowed because they have to also enjoy that. Anyhow, so they have a certain duration they allowed. It is a case when they have allowed balancing constitutional morality and social morality. This you should know that. Because social morality is that ki cultural things you are trying to adhere, right? The people were allowed to even have sounding crackers. That is social morality. This, and when you have restriction, it is constitutional morality. That is how it was in news, but because of that. Now, Khap Panchayat. So, which judgment is related to Khap Panchayat? Shakti Vahini case, 2018. This 18. वो जब न्यूज में था तब आया था क्वेश्चन. उन्होंने इम्पोज किया होगा. Basically, they impose on a couple. We know already that. So on one couple they impose that they should live like her brother and sister.
Married couple.
Yes. So it is that case. तो ये फिर से आने वाला नहीं है. Right. Now examine the scope of fundamental right, light of latest judgment, Supreme Court, right to privacy. ये तो पुट्टा स्वामी का judgment है. Yes, you can examine it. It is a straightforward question. ठीक है, चलो पुट्टा स्वामी में there are 3 criteria. What are those 3 criteria? Right to privacy can be taken away provided 3 criteria are fulfilled. Mm-hmm.
Legality, proportionality.
Legality, legitimacy, and proportionality. This. Now, किसी केस लॉ में अप्लाई है तो बता दो कहाँ पे अप्लाई हुआ है. In which case it was applied? These 3 principles were applied in which case? Electoral bonds case. This. Now, most significant achievement of modern law in India is constitutionalization of environment problems by the Supreme Court. Discuss this statement with the help of relevant case laws. Right? तो ये तो पता है when it started constitutionalization. Which case से you will start? MC Mehta case, right? बाकी आपके पास बहुत सारा कंटेंट है इसके ऊपर. अभी रिसेंट का है अरावली, isn't it? This. Now, right of movement and residence throughout the territory of India freely available to Indian citizens, but these rights are not absolute. No reasonable restrictions. There are reasonable restrictions, others. So this we can talk. Enormous this progress society. It is a simple liberty question, a generic abstract question on liberty. This. ये भी एक न्यूज में था तो उन्होंने पूछा था. Basically, Supreme Court, there was a case in which Supreme Court did not allow DNA tests, right, to verify the identity of the child, who is father. Yes. It was related to one husband, means one person, let's say, case in Supreme Court. Supreme Court, it was related to that. It was in news that time, this and that, they had asked this question. It is a very technical and specific question. This, they gave this, let's say, ki their judgment was based on this logic that ki women bodily integrity, she has autonomy, right to life, like to dignified life, gives bodily autonomy to women. Therefore, husband cannot, let's say that, just for his claim of fidelity, you know that, the fidelity cannot drive to go for DNA test. It will breach the bodily integrity of women. Yes. So that way we can consider. What do you mean by this? कुछ ऐसे केस लॉज हैं जो आपको जानना चाहिए. सारे केस लॉ ना बहुत सारे नोट्स में मिलेगा. आप कुछ केस लॉ जानो जो फंडामेंटल है. This जानने को आपको, it depends on your limits, but कुछ ऐसे केस लॉज है that is fundamental and that case law should be in mind. वो इतने फंडामेंटल होने चाहिए कि वो आपके माइंड में होने चाहिए. दिस जैसे कि हेट स्पीच है तो प्रवासी भलाई केस, एनवायरमेंट है तो MC मेहता केस, दैट वे दिस फिल्म है तो एटसेट्रा राजगोपाल के रंगराजन केस और ब्रिजभूषण केस, इंडियन एक्सप्रेस केस. तो कुछ ऐसे केस लॉज हैं जो थोड़े से मतलब फंडामेंटल्स हैं. And since case laws are important for this paper, so that is how you will find this, it is important. So that way it can be covered. Then DPSP में एक ही बार आया है क्वेश्चन, फिर से आ सकता है, तो ये कोई चैलेंजिंग नहीं है. यूनिफॉर्म सिविल कोड पे नोट मिला होगा उसमें, प्लस यूनिफॉर्म सिविल कोड में यू शुड सपोर्ट यूनिफॉर्म सिविल कोड, बट देन की we have to follow 3 steps approach. This you should know that. That is how the 15th Law Commission recommended in 2017. 17, yeah, let's say you can check. Wait. First is that you have to bring differences within personal laws.
2018.
So you have to, क्या?
2018.
2018, yes. 2018, this Law Commission recommended. There is another panel or ex-president panel that has also recommended, but they have not made it public. But when you are writing way forward, जो भी आपको लिखना है, in that you have to just, let's say, write that 3-step approach. One, each personal law should reform and become progressive. This will bridge the differences. That way, it will bridge the differences you can consider between them. So that is each personal law getting reformed, right? Now, second is that you should create a level playing field between them. Means you compare them and try to minimize the differences. Third step is merge them. Merge them. Still, 28% people will not come under Uniform Civil Codes. 28%. Law Commission recommended. अब क्या उन्होंने calculate किया, we have not seen that. But they recommended कि still 28% people will not come under Uniform Civil Code. Yes. So that is if at all they ask. Now, in the prelims wala book, you know that when you read prelims wala, so in that from the DPSP we have given in terms of articles, and we have given schemes also in each. Right. In each article, we have given some, let's say that initiative by the state. This. इसमें नहीं होगा. Polity prelims. Yes, PT booster. तो आप एक आंसर का टेम्पलेट प्रिपेयर करो. जस्ट प्रिपेयर ए टेम्पलेट ऑफ आंसर ऑफ DPSP. उसमें 2-4 आर्टिकल 5 आर्टिकल जो अच्छे जो याद हो सकता है उसका, और उसके कुछ पॉजिटिव इनिशिएटिव और नेगेटिव. बस इफ एट ऑल दे आस्क ऑन DPSP, ऐसे कि कभी they have not asked, it is not that in high priority, even if you do not prepare it. Financial emergency तो you can write simply by Lakshmikant. This इसमें और कुछ नहीं है, right? It is straight forward. उनको भी पूछना है कभी न कभी कुछ बच्चों को परेशान करने के लिए. This again they have asked.
अरे वो ये 2018 की 2 बार आप लोगों ने गलती की.
Is it like that? ठीक है, चलो, accepted. Next, amendment, let's say this. Amendments. So, what we have in amendments? Parliament power to amend constitution is limited power and it cannot be enlarged into absolute power. Right? In the light of this statement, article is this destroy, that can destroy this. Right? तो can parliament, which case law में सुप्रीम कोर्ट ने ये बोला था? No. तो वही एक बचता है अब. This. Now, why Parliament cannot amend this, expand its power? Why? क्यों? नहीं, वो तो केस ला वही है. मिनर्वा मिल्स का ही केस है वो.
Parliament is creation of constitution, not vice versa.
Amending power is also a basic structure. Right? Means ki limited amending power. Parliament enjoy only limited amending power. That also comes under basic structure. It has a limited sovereignty. This you can say this. So since it has limited sovereignty, amending power is also a basic structure. And it cannot alter the constitution. That is basic structure, it cannot alter the intent. Right. It is because of that Parliament will have only limited amending powers. This way. Means it cannot amend Article 368 and give it to itself unlimited amending power. This. That was. Why? Because the sanctity of the constitution has to be maintained as per the intention of the framers of the constitution. That got reiterated through IR Criollo case, you can say this is this way. So that way we can talk, and it is a technical question basically. This first we should, let's say ki you will explain it. This Parliament money cannot enlarge. You can simply start that ki Minerva Mills, Supreme Court in Minerva Mills case laid down, let's say, guideline for protection of basic structure of the constitution. This by giving the final verdict. This final verdict in reaction to Keshwanand Bharti case. So that way you can introduce. Then you have to write about amendability. Article 368, and Parliament has amending power. Right. One is a special, let's say that method, another is special procedure, it can amend this. So you will tell that ki Parliament has been given power to amend Constitution, including fundamental rights. Then you have to put a heading, amendability debate. However, the amendability debate since 1951 to 19, let's say that ki this amendability debate till 1980, 51 to 1980, let's say that let's say gave rise to whether Parliament can amend fundamental right, and then Supreme Court evolved basic structure doctrine in Keshwanand Bharati case. This basic structure doctrine was struck through 42nd Amendment Act. Then the final verdict was given by Minerva Mills case, in which Supreme Court reiterated and gave clarity on limitations of Parliament in terms of amending Constitution. Why it cannot amend its own power and give it power to itself. That part you can consider. So that is how we'll write as we were talking. What it says that in the light of this explain करना है. This तो कोई criticisms लिखना नहीं है. We don't have to write criticisms in that. But still you can say that however there can be other side of the view that whether it is judicial overreach and whether framers of the Constitution intended a limited amending power to Parliament. Although it's remained debatable, but the main takeaway, main essence of the Minerva Mills case is that the Constitution is a living document, but its basic structure, basic intent should not be disturbed, which is essential for maintaining rule of law.
Amending power is also basic structure.
Yes, this. So that way, let's say that we can write about this. ये दिल्ली से related है, it is not really relevant when debate was going on with NCT Delhi. Now they have changed it. Then it is related to 100. First Amendment. This ये तो GST से related है, तो again let's say that then 100 first again. Right, ये repeat नहीं है. मतलब repetition mistake नहीं है. Right. So basically, if you take amendment, this amendment and this amendment, this is current related. So that's why we don't have to prepare amendment wala part. This it will obviously naturally come when you read polity. This then next. What is this? Article 370. They to Jammu and Kashmir se related hai. Let's not like this. Constitutional morality is rooted in India itself. In the constitutional and is found on its essential facets. Explain this with our relevant judicial decisions. Right? So constitutional morality तो सबको पता है. पता है? What is constitutional morality? चलो define कर दो. Yes, yes. Yes. So, constitutional morality is George Grote. This is how it is paramount reverence to the ideals of the Constitution. But now, अब ये कह रहे हैं कि ये it is found, let's say, it is rooted in the Constitution. तो वो कहाँ rooted है? Root कहाँ है Constitution में? Yes. Where it is rooted? Yes, preamble. उल्टा सीधा भी बोल दो, क्या करना है? The preamble, the fundamental right, the DPSP, the fundamental duties. It is rooted there. And separation of power. Right? The constitutional morality is derived from the ideals of the Constitution and constitutional convention, which we have in terms of preamble, fundamental right, DPSP, and fundamental duties, including the scheme of separation of powers and checks and balances. इतना लिखना पड़ेगा रूट के लिए. Yes. And then let's say that कि thereafter क्या बोलते हैं? Doctrine है. तो किस केस लॉ से हम लिंक कर सकते हैं? Yes, yes. नवतेज सिंह जौहर केस, नवतेज सिंह जौहर केस और सबरीमाला केस, नाज फाउंडेशन केस, एनसीटी दिल्ली केस, बहुत सारे केस लॉ है। इसमें कोई सैंक्टिटी नहीं है, आप जो भी केस है उससे लिंक कर दो। कॉन्स्टिट्यूशनल मोरालिटी लेट से रिलेवेंट जुडिशियल डिसीजंस, यू कैन लिंक इट। वो नोट्स दिया है, वी हैव गिवन कॉन्स्टिट्यूशनल मोरालिटी नोट्स, यू रीड इट। Do we have written this? Right. Is it? No, 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 no. यहाँ पे वो नहीं लाएंगे। Just will focus on Indian side, right? Yes. Explain the constitutional perspective of gender justice with help of relevant constitutional provisions and case laws, right? तो जेंडर पर्सपेक्टिव तो बहुत सारे हैं, यू कैन रिलेट व्हाट कैन बी द केस लॉज। यस, ट्रिपल तलाक है, नौतेज सिंह जौहर नहीं आएगा। जेंडर हालांकि ठीक है, वो भी इंक्लूड है। राइट, ये शाहबानो केस, शाहबानो टू सायरा बानो, दिस दैट वे, ट्रिपल तलाक टू शाहबानो राजीव गांधी वाला टाइप, दैट कैन बी कंसिडर्ड। तो दैट ऑल्सो यू कैन रीड। शक्ति वाहिनी केस, दिस उसी के पैरेलल में वो मिलिट्री वाला केस था, दिस women were allowed in commissioned service, this that way you can link those things. It is general, not means वहाँ से भी क्वेश्चन आता है। लेट्स टेक ऑन एग्जीक्यूटिव साइड। Right. The President Committee death sentence has come under public debate. Should there be a limit specified by President to reject petition? To which case it is related? Yes? शत्रुघ्न चौहान केस, शत्रुघ्न चौहान केस, चौहान केस 2014, that on the grounds of delay in execution of death sentence, the court can convert that sentence into life imprisonment. This way. So it is this case which gave rise to debate on since there are inordinate delays. Right. The empirical evidence shows that it has taken 10 years, 20 years, even 30 years. Right. After, let's say, court has given final verdict, in execution are taking decision on death sentence, including those cases related to Rajiv Gandhi assassination, Devender Pal Singh Bhullad, that case. So there should be limit that it can be 3 months, it can be 6 months. The president should take decision within a time frame. That will bring, let's say, that practice of rule of law. This, when after verdict is given and then you execute the verdict, it is, let's say, about adhering to rule of law. When you delay it, it undermines rule of law. Yes. So that is how it can be considered. नहीं, उसमें ये नहीं है, वो सब अननेसेसरी होगा। लेट्स एनीहाउ, ये एक ही बार आया है जब वो डिबेट में था 2014। इसलिए कई सारे PYQ से घबराना नहीं है, डोंट गेट पैनिक ट्रबल्ड बाय दिस। इसलिए कि वो नहीं आता है तो नहीं आता है ना, वो उस समय आया था। यू शुड नो दिस एज ऑफ नाउ कि क्या हो रहा है अभी, दैट वी हैव टू नो। तो दिस वे लेट्स से इट इज नॉट, एंड दे डोंट आस्क दैट वे लेट्स से दिस अगेन कि इट इज ए टसल गोइंग ऑन। अब तो ये खत्म ही हो गया है, गवर्नमेंट ने दूसरा ही कुछ स्कीम लाया है। तो गवर्नमेंट हैज ब्रॉट पब्लिक सर्विस, कुछ एक्ट है इस तरह से, पब्लिक सर्विस एक्ट समथिंग वो होगा, दिया होगा कहीं पे, उसमें है वो प्रीलिम्स वाले में पीटी बूस्टर। कुछ चीज़ें वहाँ पे चूंकि दैट वी रोट लेटर, आई हैव इनकॉर्पोरेटेड इन देम दिस, तो उसमें यूटीज वी हैव कवर्ड क्वाइट बेटर। पीटी बूस्टर वाला वी हैव कवर्ड यूटीज इन वाइट detail, even governor we have covered in quite detail, you know, governor, UTs, that way. So I think you can take from there. It is mentioned, public service wala mention, you can read, that is expected question. Yes. Means in UPSC, we will not ask at least in 3 days. Next is, to what extent parliament is able to ensure accountability of executive? तो parliament का question है. This is next week वाला question है, right? This governor they have asked once. This is how, that is ordinance related. They discuss the essential condition for exercise of legislative powers by the governor. This essential conditions for exercise of legislative powers. What are essential conditions? Then discuss what can be essential conditions.
State legislative assemblies are not in session. There is urgency, and then there are 3 provisos into the 213 article. And those 3 are forgetting right now.
Right. Yes, the conditions can be related to recommending precedent rule, giving sanction to bill, this exercising other discretions related to some of the states enjoying special powers. That way, including proclamation of ordinance, कि ordinance से related है.
Legislative power, I think we should limit to ordinance.
Yes, yes.
Exercise of legislative powers, so we should limit to ordinance rather than proclamation of emergency or anything.
No, but वो कह रहा है कि इस general quest part है ना, it is a general part. Discuss the essential conditions for exercise of legislative powers.
Sir, I think the question is limited to ordinance because the second part itself is also again about pre-promulgation.
No, you are not getting. That we can mention to give a broader aspect. In that we can mention ordinance. This, that way. अगर उनको सिर्फ ऑर्डिनेंस पूछना होता तो वो ऐसे पूछ के डिस्कस द ऑर्डिनेंस मेकिंग पावर ऑफ गवर्नर, और सेकेंड पार्ट में वही पूछते रिप्रोमलगेशन. दिस नो, इट इज नॉट है, वी शुड नॉट मेंशन. मैंने वो मिस कर दिया, लेजिस्लेटिव. राइट. कॉलिंग हाउस टू सेशन नहीं, वो सब नहीं सर, वो तो एडवाइस पे होता है. एक्सरसाइज ऑफ पावर्स रिलेटेड टू बिल्स, बिल्स रिलेटेड पावर. राइट. नाउ डिस्कस द लीगैलिटी ऑफ रीप्रोमलगेशन ऑफ ऑर्डिनेंस. ये बता दो आप. No, what is legality of repromulgation?
It is still legal.
Repromulgation. Yes, लिखे हैं तो you tell it.
Re-promulgating ordinance without getting it passed, without making attempt to getting it passed is illegal.
What is legality of repromulgation?
It is legal.
ऐसे नहीं होता है. What is Vadva exception?
It is allowed, Supreme Court is not barred for
ordinance can be removed.
Yes, ठीक है. You will revise. You will know that. Accepted, not that challenging. Legality of repromulgation means that कि in DC Vadhava case and then in कौन सा case? Krishna Kumar case. Right. So DC Vadhava case and then Krishna Kumar case. This matter came for repromulgation. Whether repromulgation can be declared unconstitutional. As Article 123 or let's say its counterpart for governor, right, that deals only about ordinance, not repromulgation. This. The DC Vadhava allowed repromulgation on some grounds. And those grounds when DC Vadhava allowed, that is called legality. That repromulgation per se is not unconstitutional, but its frequent practice is fraud on constitution. Yes. So what is that ground? The legislature may not be, right, in session. There can be situation like COVID crisis. Second, ki legislature can have impending business. It can have so many business and it may not be able to cover, you know that. It may not be able to cover that ordinance and therefore it should be allowed for repromulgation. That came to be known as, let's say that ki legality. So that is how you have to write it.
Second case, the house may be in the session. In the second case, the house may be in the session, right?
Means?
Means like even if the house is in session, there can be repromulgation.
No.
You told if there is not pending before the house.
No. It's like, try to understand. Why there can be repromulgation? Because one ground they gave in DC Vadhava case is that ki the house have lots of business to cover. So it may not be able to take into consideration the ordinance wala matter. This ordinance wala matter it would not be able to cover. So then that it will be allowed to lapse, it can repromulgate. But it will not repromulgate when the house is in session. This, it is like this. No. Is it problem?
रिप्रोमल्गेशन मतलब जो लेजिस्लेटिव अभी सेशन चल रहा है और लेजिस्लेटिव कोई भी काम वगैरह जो पेंडिंग है तो उस हिसाब से अपन उसको ऑर्डिनेंस को रिप्रोमल्गेट नहीं कर सकते ऐसा बोल
यस, जब सेशन में हाउस होगा तो कैसे ऑर्डिनेंस इशू कर सकता है? नहीं कर सकता है. बट why there is a need to repromulgate when there is a house in session, so it should consider that ordinance. But it may not consider because it has already so much of business to consider. So somehow it may not get time to consider that ordinance and therefore it may, the executive may allow the ordinance to lapse. It may not approve it and then once house session ends, it can repromulgate it. It is like this. Right? Anyhow, so let's say count legal political factors responsible for reduced frequency of issuing president rule. No, ये तो याद होना चाहिए. What is legal factor? नहीं, legal factor तो judicial review नहीं होगा. चलो आधे पॉलिटी का रिवीजन हो गया. Right. नहीं 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 नहीं, देखो लीगल फैक्टर तो एसआर मुंबई केस है ना.
ऐसा बोलोगे तो फिर वो 2015 वाला भी केस बोल सकते
यस, आज के डेट में अगर हम आंसर कर रहे हैं 23 में आंसर कर रहे हैं तो एसआर बोम्मई केस, लीगल फैक्टर इज एसआर बोम्मई केस. In SR Bommai case, for the first time, it is declared that the president rule can be, even if it can be declared unconstitutional, and a dismissed government can be reinstated. This. Now, thereafter, which case you have? Right. Bhutta Singh case. Right. Nabam Rebia. Right. NABAM. Nabam Rebia case. Bhutta Singh case and Uttarakhand case, right? This way. Uttarakhand, Harish Rawat government. Now, what is political factor? Yes, the coalition government, the multi-party government, let's say coalition government. Any other?
Strong state governments.
Yes, emergence of strong chief ministers. This. और कोई factor? 7 points लिखना है. और क्या है? कोलैबोरेटिव, कोऑपरेटिव फेडरलिज्म. Collaborative cooperative federalism will also discourage the government to misuse that powers. और क्या है? Active citizenry, more aware citizenry. RTI you have, social media you have. These things, right? डबल इंजन भी नहीं आएगा, इसलिए कि वो तो सेम ही गवर्नमेंट हो गया, राइट. बट एंड वी गेव सम एम्पिरिकल फैक्ट्स आल्सो, कैसे डिक्लाइन हुआ है, isn't it? Right. तो आई थिंक देयर आर 28 or 30 प्रेसिडेंट्स रूल देयर आफ्टर, और उसके पहले 80 के आसपास होंगे, ऐसे ही कुछ होगा, राइट. टाइम्स ऑफ हिंदुस्तान टाइप्स ने जो फैक्ट दिया था. एनी हाउ, नॉट नीडेड, कोई ज़रूरी नहीं है. This. Now, this ministry, size of cabinet should be as big, let's say this.
Active president वाला है.
Active president तो नहीं आएगा.
एक केस हुआ था, I remember it.
But that is 1997, 1998. KR Narayanan case. तो वो भी लिख सकते हैं, कमीशंस रिकमेंडेशन भी लिख सकते हैं.
Just to increase the point.
Yes, yes, बिल्कुल. We can write that KR Narayanan case. The KR Narayanan Miss Presidential, let's say that की active role by president, आप एक point लिख सकते हो ये. दूसरा point आप लिख सकते हो recommendations by commissions. सरकारिया कमीशन, पुंछी कमीशन. तो इस तरीके से point बनता है. राइट. ये एक अपने ऐसे ही क्वेश्चन आते हैं जीएस में, लेट्स सी, जो कभी आपने सोचा नहीं होगा. तो द साइज ऑफ कैबिनेट शुड बी एज बिग एज गवर्नमेंटल वर्क, राइट. जस्टिफाई एंड एज बिग एज प्राइम मिनिस्टर कैन मैनेज द टीम. हाउ फार द एफिकेसी ऑफ गवर्नमेंट देन इज इनवर्सली रिलेटेड टू साइज ऑफ कैबिनेट. राइट. कौन से क्वेश्चन है? 14 का क्वेश्चन है. This speech without evidence and cause enmity between groups. Right. Try to understand. We have told somewhere, right? Or you should be aware that there used to be the size of the Council of Ministers, like even crossing 100. In coalition era, there used to be something even 105. This, that one. So it becomes political accommodation. It becomes political accommodation this way. when it becomes very big, let's say that, ministries, it is very difficult to carry, let's say, manage. This we can say. Too big to be governed effectively, jo hota hai, right? This. That you can write. This. Then you can give some comparison, let's say, largely in the countries, if you take, let's say, different countries, we give that. Ki Japanese, let's say Japan, you can say, UK, you can say, US, you can say that. Largely the size of the, let's say, council of ministers remains limited to 20-30, let's say this, that way. Plus, it will also result into overlapping, let's say that, unnecessarily overlapping, right? Plus, you can take ARC second recommendation into consideration. This, what ARC second has recommended? Principle of subsidiarity. This, the principle of subsidiarity means that the central government should have limited subject matters. Another subject matter should go to, right, states and local. Next is ARC first also recommended. The size of council of ministers should be 45 and cabinet should be 14-15. This, that was recommendation. So it is true that the size of council of minister can be directly proportional to efficient working of the government. The smaller the size, manageable the size, then prime minister can lead the team effectively. If it is the bigger, there can be more, let's say, time going in accommodation rather than leading the team. That is largely happen in coalition government. But when, since 14 mein aaya hai question, so when a new government has come with full majority, this, when it has come with full majority, that there will not be political accommodation, and then the government will, already we have 91st Amendment Act, and 91st Amendment Act also caps size of council of ministers, right? So this way you have to write. It is about legislature side. This others will take next day. Right, straight 73rd Amendment, फेडरल पॉलिटी भी देख लेते हैं क्या है. Separation of power. Supreme Court checks arbitrary parliamentary amending. तो लिख दोगे आप, इसमें कोई ज़्यादा चैलेंज नहीं है. Ordinance फिर से आ गया. Already we have a discussion on that. Critical examination of national judicial appointment. So you can write on this, not a problem, isn't it? Judiciary का भी topic separate है, तो it will come again. This. Then resolution, this legislative power, principle of federal or harmonious construction have emerged to explain, let's say this. Right. ये आया था दिस 19 जम्मू एंड कश्मीर का जब इशू चल रहा था तब. दिस, राइट. आर यू अवेयर ये क्या है दोनों टर्म? Right. Federal supremacy is that it's about the union remaining strong over states. This you should know that. So our federation should work within the scheme of that union remaining strong over states. That does not mean that states should become subordinate units. This way, federal supremacy term was all used by Sarkariya Commission. This. And he told that there should be federal supremacy, otherwise our federation will not survive because the challenges that you have. This way. Now, even if you maintain federal supremacy, but they should solve their problems, differences, tensions and issues through harmonious construction. That is called dialogue, cooperation and collaboration. Like say GST Council, Interstate Council. This way. That is how the context it can consider. Now, do you think that Constitution does not accept principle of strict separation of power? Rather, it has principle of checks and balances? Straightforward question. This we don't have is, let's say, rigid separation. This judicial legislation, it is activism. We'll talk later on. Constitutional guarantee judicial independence. We'll talk later on. It's when judiciary comes. This interstate river dispute, it was a specific question है, तो you can read river disputes at sectors, isn't it? Either failure due to structural process or process inadequacy or both. चलो ये वाला part discuss करते हैं. Is the failure due to structural process or both? What is structural, by the way?
बॉडी नहीं बना रखी है कि इश्यूज को रिजॉल्व कर सके वो
तो प्रोसेस क्या होगा?
So we have to critique the parliament's way of functioning and following the mechanism to settle such disputes.
Yes, you should know that. Means no. First structural is constitution. Right. The process we can take. First problem is constitution itself. The subjects have been defined, means divided in the schedule 7. That itself is the origin of dispute. This. Basically, water should have been in concurrent list, not in state list. This you can say. And the interstate river water or larger aspects should be in union list. What they have done is, water is in state list, but state does not have independent source of water. This, the hydrological, let's say that evolution of our society, let's say the way hydrological evolution has happened, in that hydrological evolution, state does not have exclusive jurisdiction on water. Right, especially river water. A river flows from one state to another state. So the flaws goes in when the constitution itself was written and adopted. That is a structural dispute. This second structural dispute comes is that the constitution bars role of judiciary, but then the judiciary has intervened. This now come to the process inadequacy. The process is that we have created river tribunals, right? Dispute tribunals we have created. River board we created, but river board never functioned. This and tribunals, they have taken their 15 years time. By the time course of the river changes. Right. It is both. We have to write both aspects, let's say. So that is how the question, let's say this. Anyhow, तो ये तो ऐसे ही एक न्यूज़ में आया था तो क्वेश्चन आ गया था उस समय. तो we'll escape it. Now, federal principle is dominant in our constitution and the principle is one of its basic feature, yes, but it is equally true that federalism under Indian constitution leans in favor of a strong center, a feature that militates against the concept of strong federalism. Right? A strong federalism is different from federal supremacy. A strong federalism means a very healthy relationship between union and states. So, वो militate कैसे करता है? How it militates a strong center? No, आपको तो डेवलपमेंट्स का देना पड़ेगा. Example, how when center is strong, how it affects development of strong federalism. Yes, that is a good example. So that is what, let's say कि center can impose policies on states this way because it has been given coercive powers. It enjoys coercive power. This being a strong federation. This way, strong financial power. It can punish states. This one is three language formula. This then basically investigating agencies, they bring conflictual aspect. Is centrally sponsored schemes. This and the conflict, let's say that you can consider. These are some of the things which result into conflictual. Office of governor, president rule, office of governor, issues related to recent Tamil Nadu, Karnataka, Kerala, Punjab. तो बहुत सारे points हो गए ना, right? This so that way, let's say it results into this. बाकी way forward में वही होगा, blah blah things, right? Isn't it? Next, cooperative federalism. Recent years highlight drawbacks in existing structure, right, and the extent to which cooperative federalism would answer the shortcomings. Right. तो हमारे फेडरलिज्म, let's say that कि concept of cooperative federalism में क्या प्रॉब्लम है? स्ट्रक्चरल प्रॉब्लम. Cooperative federalism, you can write, isn't it? Cooperative federalism means when union states cooperate, right, the cooperates in legislative, executive and administrative affairs. The Indian Constitution is cooperative constitution. The Indian Constitution provides for cooperative federalism. किसने बोला था? Yes? ऑप्शन प्रीलिम्स है क्या? चलो मल्टी डायमेंशनल हो गया आपका टेस्ट, isn't it? साइकोमेट्रिक टेस्ट. ग्रैनविल एस्टिन. यस, तो ग्रैनविल एस्टिन भी लिखोगे आप, ठीक है? बस कुछ प्रोविजंस लिखोगे जो कोऑपरेटिव फेडरलिज्म प्रमोट करता है फर्स्ट पार्ट के लिए. और रिसेंट ईयर्स में क्या स्टेप्स है जो कोऑपरेटिव फेडरलिज्म को प्रमोट करता है? नीति आयोग और जीएसटी काउंसिल और क्या? इस तो कॉम्पिटिटिव फेडरलिज्म है. कोऑपरेटिव फेडरलिज्म इंटर स्टेट काउंसिल तो पहले से है, लिख सकते. यस, फाइनेंस कमीशन अडॉप्टिंग कोऑपरेटिव एटीट्यूड पर्सपेक्टिव, 14th 15th फाइनेंस कमीशन. रीस्ट्रक्चरिंग सेंट्रली स्पॉन्सर्ड स्कीम्स, ग्रेटर डेवोल्यूशन ऑफ पावर टू स्टेट्स. दिस राइट. तो ये सारे हो जाएंगे. अब उसमें फ्लॉ क्या है? हमारे एग्जिस्टिंग कॉन्स्टिट्यूशनल स्ट्रक्चर में फ्लॉ क्या है? तो स्ट्रॉन्ग यूनियन, दिस यू कैन से स्ट्रॉन्ग यूनियन, coercive power, more financial power, this you can consider, given to center. This non-consultation of states when finance commission term of reference is decided, additional term of reference, that can be considered. This तो lack of consultation in centrally sponsored schemes, तो ऐसे करके आप लिखोगे. Then how it can address cooperative federalism? It can sort out differences, it can bring consultation, participation, this sharing of ideas, and let's say that ki decision, the way GST Council or Niti Aayog, they have played positive role this way. That can be considered. ये तो फिर से आ गया 35. Is it like that? ये क्या हो गया? Anyhow, दैट इज ऑलरेडी इट इज अ रिपीटेड क्वेश्चन. ये तो एक बार आ गया कोविड के टाइम पर. हाउ फार डू यू थिंक कोऑपरेटिव कॉम्पिटिटिव कन्फ्रंटेशन हैव शेप्ड नेचर ऑफ फेडरेशन इन इंडिया? अब इसको बता दो कि मतलब क्या है. व्हाट इज द मीनिंग ऑफ द क्वेश्चन? Mm-hmm. Yes, competitive federalism. Those who do not know, the cooperative federalism we have defined. Competitive federalism means, let's say, when union promotes competition among states in federal relations, largely it is being done through Niti Aayog. The Niti Aayog has, let's say, prepared some indices through which states are given ranking. Let's say aspirational district initiative, smart city mission, this kind of thing. Plus, competitive state is also the Finance Commission has adopted performance as a criteria. When performance as a criteria in financial devolution has been added, that also brings, let's say, competition among states. It is called competitive federalism. Confrontational तो पता ही है आपको कि they have wrestling every day. So anyhow, conflictual federalism is confrontational federalism. Right. Now, how three are shaping federal in our country? This is the question. How they are shaping the federal aspect in India? How cooperative, competitive, and confrontational, they are shaping, let's say, nature of federation in India. Yes, the nature is, on the one hand, it is becoming more and more collaborative and cooperative. There is greater consultation, cooperation between them. And you can give example of GST Council. It has more than 56 meetings. It is a successful federal institution this way. But on the other hand, it is resulting into states becoming also more assertive. They are becoming more assertive, you can consider, in their, let's say, that role in terms of, let's say, their grievances and projection of their matter. You can see how southern states, let's say, 3-language formula. Then Maharashtra and Tamil Nadu, they have rejected it. This states also reject to, let's say, simply they reject some of the policies and programs of the government. This, like say CA you can consider, 84th Amendment Act, 138th Amendment Bill you can say as of now. So it is resulting into cooperation on the one hand, but assertiveness of the states on the other. That assertiveness is on the whole trying to make our federal polity more even rather than becoming more strong, let's say, union, and weak states are less coercion, more collaboration. Like the resultant emphasis or resultant outcome is it is giving rise to more collaboration rather than confrontation. That way you have to, and that is called also remaking. This is how we say remaking of Indian federal polity, you can say. So that way this question. Now CBI का एक बार क्वेश्चन आया था ऑलरेडी, यू नो, इसमें कोई ज़्यादा डिस्कस की बात नहीं है. Right. CBI is, however, power of states to withhold consent to CBI is not absolute. Explained with special reference to federal character. क्या है, कैसे मेंशन करेंगे CBI consent is not absolute? What you will write in this part? No, वो नहीं होगा line of thought. Yes, yes. स्पेशल कंसेंट, जनरल कंसेंट, बट वो इशू नहीं है इसमें. A state cannot simply withhold consent to state, be it general or special, simply because we have federal supremacy. Right? We cannot have clear a wall between union and state relations. This you can say that. So when a state goes on withdrawing consent, it is trying to create a clear separation of power. But Schedule 7 does not have clear separation of power. This you should know that. And when any incident happen, any crimes happen, that crimes happen against the entire society, rather than कि a particular section or a particular state. This. And if that crime is not investigated, it affects the entire society, not a particular state. This. So from federal supremacy perspective, state may lack this power to withdraw consent. This, that you can say. Especially their general consent. This. So that is how the idea. That time also वो federal supremacy वाला matter आया था. Right. तो you debate से पता चलेगा. तो people may have paid attention to that time when this question was this. Now, while the national political parties in Indian favor centralized regional parties, ये तो आप ऐसे ही लिख लो. इसके सब कुछ डिस्कस नहीं कर सकते. What changes have in institutional domain of central situation? Yes, you know that this trust between this that. If he general changes introduced by center and then strengthening federal. Right. General है नहीं है. I will skip. लोकल पंचायत, ये तो स्पेसिफिक टॉपिक है. यू रीड इट. जो नोट्स होगा वैसे भी आपके पास भी अपने नोट्स होंगे. राइट. इसमें बहुत ज़्यादा टेक्निकल है नहीं समझने का. ऑप्शंस ऑफ वेल एजुकेटेड ऑर्गेनाइज लोकल लेवल गवर्नमेंट्स पंचायत समिति हैव रिमेन मेनली पॉलिटिकल इंस्टीट्यूशन नॉट इफेक्टिव इंस्ट्रूमेंट ऑफ गवर्नेंस. वो तो उस समय बेसिकली ये सारा हरियाणा, मध्य प्रदेश, राजस्थान, उड़ीसा, द इशू वाज गोइंग ऑन बेसिकली क्वालिफिकेशन. They should have qualification to get eligibility. This that Rajasthan adopted, Haryana adopted like this. तो वो उस debate से related है basically. But then you should negate it कि this education may not have to do with political leadership. You know that. This way there is no direct link with leadership effectiveness and education. That if they are not effective, it is because of other factors you can consider. Not necessarily education, you can say this. So that way let's say local self government effective instrument of, ये तो generic question है, आप जितना लिखना है लिखो. This then importance of panchayat, local government, this grant source, panchayat finance. It is related to finances. ये specific question है. इसमें आपके पास specific facts होना चाहिए, isn't it? So finances, they have sources of finance, right? They have sources of finance. तो local bodies का अपना source क्या है? How much they generate by their source? ये तो पता होना चाहिए ना. Macro facts तो yes 10%. They are able to generate 10% of their source of revenue. Now, अब क्या बोलते हैं local government, this grants apart from sources. What are their sources by the way? और क्या है source उनके पास? What are sources? Right. According to World Bank, they have over 78 different types of taxes. This. राइट. उसमें आप जितना आता है आप लिख दो. मार्केट टैक्स, लैंड, let's say revenue, that kind of thing you can say. So you can mention those things anyhow, but they are not adequate, plus they are not collected. This That way. That's why they may not generate more than 10%. There are some good states like Kerala and Maharashtra. They generate highest per capita income for panchayat finances. That way. So what should be done? क्या करना चाहिए? State Finance Commission. The State Finance Commission should play a constructive role like Union Finance Commission. It can suggest the ways and means how local bodies can generate finances so that they can overcome challenges of lack of financial generations. That's it. The best practices can be promoted. User charges concept should be promoted. There can be also common municipal bond system for the panchayats also on the pattern of urban local bodies. This. तो दिस वे लेट्स से दैट कि यू कैन राइट बाकी कुछ गलत भी लिख दो सुपरफिशियल यस पीपीपी आल्सो लेट्स से तो पीपीपी आल्सो कैन बी दिस पंचायत कर सकता है वो जिला परिषद कर सकता है आजकल वो बड़ा बॉडी है वो सेल्फ हेल्प ग्रुप जिला परिषद कर सकता है तो सीयू है आईएएस राइट तो सारा डेवलपमेंट तो उन्हीं के थ्रू होता है तो दे कैन डू दैट लोकल लेवल दिस anyhow the reservation seats for women etc local had limited impact on patriarchal this why it has limited impact और facts क्या लिखोगे do you remember now let me tell that कि basically what you should focus when you revise these things these are the sectoral question आप खुद से पढ़ो ये अपने से भी पढ़ के देखो कि क्या किस तरीके से क्वेश्चन आता है and you should know कि there are sectoral question there is a generic question there is a sectoral question so this is generic question this is a sectoral question this women reservation they have asked finance they have asked then this is 3F they have asked functionality they have asked it is a general question on decentralized landscape so this is about everything it will come social audit citizen charter our right to service act this 73rd 70 because it is decentralized let's say landscape you can consider realize local bodies providing good governance this pros and cons merging let's say rural and urban bodies this what they have not asked so far the Gram Sabha has not been asked you should know that the State Finance Commission has not been asked and somewhere once they ask about role of Finance Commission kabhi aayega also you have to know role of Finance Commission in strengthening finances of local bodies these things can be more of NYQ type this way and that is what we can consider अभी और भी टाइम आएगा मतलब कि सारा एक ही दिन में नहीं होगा जब फुल एंड टेस्ट होगा तो कुछ ना कुछ आएगा ही तो व्हेन वी कैन हैव डिस्कशन तो वी कैन टॉक ऑन दिस तो इससे क्या पता चलता है व्हाट यू कम टू नो 2-2.5 घंटे में क्या पता चला कुछ पता चला बिल्कुल तो यू शुड आंसर थ्रू की टर्मिनोलॉजी होना जरूरी है अदरवाइज योर आंसर विल बी लिटरेचर सिंपल हर चीज़ का अपना टर्मिनोलॉजी है जब आप शॉर्ट नोट्स लिख रहे हो वहीं पे वो सारे टर्मिनोलॉजीज लिख लो दिस वे इतने भी ज़्यादा नहीं है कि लेट्स से बट सिंस हम ध्यान नहीं देते वी डू नॉट फोकस टू देम और वी डू नॉट कीप इन माइंड ठीक है प्लस आप ये सोचो कि आपको व्हेन यू आर राइटिंग द फर्स्ट पॉइंट इट शुड बी द मोस्ट इम्पॉर्टेंट पॉइंट इट शुड बी इन ऑर्डर ये नहीं कि लास्ट पॉइंट जो याद आ गया पहले तो उसी को लिख दिया वो तो ठीक है अलग बात है बट यू ट्रेन योर सेल्फ प्लस किसी चीज़ को डिफाइन कर रहे हो ना आप, जैसे कोऑपरेटिव फेडरलिज्म ही डिफाइन करना है, कोलैबोरेटिव ही डिफाइन करना है, तो वट एवर यू डिफाइन इट शुड बी द मोस्ट अप्रोप्रिएट डेफिनेशन। ये होना चाहिए, बहुत ही प्रिसाइज एंड मोस्ट अप्रोप्रिएट। यू हैव टू गिव फोर्स योर माइंड लाइक दिस, दिस इज कॉल्ड आर्टिकुलेशन। जब तक आप फोर्स नहीं करोगे तो आप डेफिनेशन जो लिखोगे वो बहुत ही लेंदी होगा। तो पता चला एक पैराग्राफ में कोऑपरेटिव ही लिखते रह गए दिस, तो फिर वो कोऑपरेट करेगा नहीं आपसे। दिस, तो वो क्रिस्प होना चाहिए और उसमें सेंटेंस के ऊपर जाना ही नहीं है, सेंटेंस पर जाना नहीं, आपको सेंटेंसिंग नहीं करना है। मतलब कि कोऑपरेटिव फेडरलिज्म इज अबाउट व्हेन टू स्टेट्स एंड यूनियन डिफाइन, फॉरगेट अबाउट दिस। कोऑपरेटिव फेडरलिज्म, देयर इज इंस्टीट्यूशनल मैकेनिज्म फॉर कोऑपरेशन बिटवीन यूनियन स्टेट्स लाइक नीति आयोग और इंटर स्टेट काउंसिल। It is a constitutional feature. Granular talks also that कि Indian Constitution has constitutional feature. Granular का सेंटेंस ही मत लिखो, सिर्फ granular डैश राइट कोऑपरेटिव कॉन्स्टिट्यूशनलिज्म, बात खत्म। यस, तो जो सेंटेंस लिखना है, इट इज दिस दैट, वो सब जितना न्यूट्रलाइज कर सकते हो कर दो। राइट, जो पॉइंट आता है वो सिर्फ इट इज को छोड़ के बाकी आना चाहिए। These are the tricks, right? नहीं तो फिर आंसर, तो फिर देखते हैं कल क्या आंसर में आता है।
सर एक बार 2022 वाला क्वेश्चन जो उसको डिस्कस करना है, टू व्हाट एक्सटेंट इन योर ओपिनियन, हमारे ओपिनियन में आपका चलता है किसकी सोच?
Yes. To what extent it has changed, right? It is to some extent and it is changing to large extent. मतलब to some extent it has changed, but it is, let's say that कि transitioning towards large extent, ऐसे लिखेंगे, right? This. Now what are that changes? तो you have to combine, जैसे वो social capital वाला भी combine करते हैं, right? You draw something social capital type, link with this so as rather you mention it is rural landscape, that's it. This और भी कुछ है? Enough. इसी में सिविल सोसाइटी भी लिख दो। This. और then you write कि they are all interconnected and they are trying to reinforce each other. किसी एक दूसरे एग्जाम्पल से एक्सप्लेन कर दो, right? वो सोशल ऑडिट से ही एक्सप्लेन कर दो। सोशल ऑडिट, तो सोशल ऑडिट इज ई ऑडिट ऑल्सो है। सोशल ऑडिट कैन ऑडिट राइट टू सर्विसेज एक्ट ऑल्सो। सिटीजन चार्टर को भी ऑडिट कर सकता है, ग्राम सभा को भी करेगा। इट कैन अप्लाई RTI टू सीक इंफॉर्मेशन एंड दे कैन हेल्प। तो इट इज ट्रांसफॉर्मिंग द रूरल लैंडस्केप, दैट ए न्यू टाइप ऑफ let's say governance is emerging, right? Which we can simply learn by one thing, that is called social audit. That 63% panchayats have done social audit. If we have, let's say 2.5 lakh panchayats, and in that 63%, it's very huge. किसी एक एग्जाम्पल से आप दे सकते हो इस तरीके से, तो दैट वे वी हैव टू आंसर। तो ये काफ़ी बहुत बड़ा क्वेश्चन है, इट्स बहुत ही इंक्लूसिव है बस। तो कभी कभी आप देखोगे कि क्या करते हैं वो, बहुत ही इंक्लूसिव क्वेश्चन आता है, कभी कभी बहुत ही स्पेसिफिक क्वेश्चन आता है, दोनों है, और एक मॉडरेट भी होता है, मिडिल, neither very inclusive nor very specific. That should also be in mind, and this is how you should prepare for that, right? Yes, the now next is that कि we will upload 3-4 मतलब question for 3 days, right? And you write it. This we will upload. We'll try to upload by 7 o'clock in morning. This you can upload and write. If you want to write in institute here, this so when you come to the way you get test copies etc., they will give you. You can write. You can submit here after writing. Try to follow the time limit, the limit which is given that time if you are coming here. Otherwise, you can write at home also. You can come to submit or you can upload at the portal. Portal का सबको access होगा ही. That you all have access to portal. So on portal you can let's say upload your answer. It will be evaluated, given this back to you. We'll try to check by tomorrow itself, means the same day. That will try to, let's say, ensure it is checked on same day. This way. Then you can take your feedback etc. on that. The process will continue. We'll have our meeting on next Monday. This Sunday we'll skip it. I'll cover this CD later on. Right. Actually, थोड़ा सा मेंस का चल रहा है, तो taking this class मेंस time is unthinkable and बहुत ही challenging है. But since we have started it, so I want at least one ED. So next year Sunday we'll have ED. Right? So we'll meet on Monday. तो Monday को मैं feedback भी दे सकता हूँ जो आपने लिखा है. This is how. And try to cover the most important thing that we have said. The questions also you can say कि हर चीज़ से question नहीं आता है. तो syllabus इतना बड़ा हो सकता है, but if you work on the thing which are important, it will be less burdensome. Bas. So let's take now.